This is from day 30 of the Karen Reed criminal trial. The defense called Dr. Frank Sheridan. He's a forensic pathologist. He retired in 2022. He was the chief medical examiner in San Bernardino, California. They showed him a photo of John's arm. He called them abrasions. He said they're caused by friction and they're categorized as blunt force. He said the injuries were sustained before death. Little asked, are the injuries consistent with being struck by a vehicle while holding a drinking glass? And Lally objected. So she tried again. Are they consistent with being struck by a motor vehicle? Lally objected. Little tried again, differently, and Lally objected again. If Lally is so confident, why not let it go? There's no rule that says you have to object to absolutely everything that you're allowed to object to. Ultimately, after sidebar, Little was able to phrase the question, and the doctor said those injuries are not consistent with being struck by a vehicle. He said one of the big reasons why is that there's no bruising. Not only did he say it was not consistent, he said it doesn't look even remotely like an impact. He said he would at least expect bruising, and very often they see fractures. This doctor does have some experience with animal attacks. His experience, he said, is primarily with children who were killed by dogs. He's had other cases in which a dog was involved but wasn't the cause of death. He testified that the injuries to O'Keefe's arm are consistent with an animal attack. He said he thought both claws and teeth, but he couldn't say for 100% sure because he didn't analyze it closely. They had him use the laser pointer, and he pointed out the various injuries, and he described them and categorized them very similar as Dr. Russell did. Importantly, he pointed to the marks on the elbow and said that one did look like a bite mark. And he showed here's where the teeth are. And his testimony and his assessment was the same as Dr. Russell. So we have two medical experts who testify to the same thing independently, that these injuries look like they were inflicted by a dog, and they even describe one of the injuries in exactly the same way. And as for the explanation of the other injuries on the arm, the two experts' testimonies were very similar in respect to the way the words used to describe them, with the conclusion being ultimately the same. Now contrast that with the medical examiner who said they could be consistent with injuries from a dog, and she wouldn't say that they were inconsistent with a motor vehicle strike. However, she said that's not the classic kind of injury that you would see. Little presents a hypothetical, and the hypothetical was exactly the Commonwealth theory. And using that hypothetical, she asked if the injuries are consistent with that hypothetical. Well, Lally objected again. She's presenting his own theory. If he is so confident in his theory, why not let this go? If the Commonwealth theory is correct or even consistent with, then the witness's answer could only bolster the prosecution's case. But Lally knows it's nonsense. As a result of his objection, they ended up at sidebar, and then everybody was out of the courtroom and they were on a break. When they came back from sidebar, Little was able to ask the question again, and the doctor said that the injuries on John's arm were not consistent with being struck by the vehicle or that taillight. He said there was no bruising on the arm. He would have expected to see that. And he would also expect the injuries to be worse. And he pointed out that the injuries were patterned. They move on to the head injury. The doctor says there was an impact to the back of the head. He described the injuries the same way as the ME described them. He said there were extensive massive bruises in the brain in multiple areas. Again, this is the same as the Commonwealth's own expert witnesses. He described brain swelling and herniation of the brain the same way as the neuropathologist described them. He said the injury sustained to the head would have caused a loss of consciousness. And I want to talk about this for a second. That would mean he wouldn't be sitting or standing or crawling or doing anything. He'd be unconscious. He's not getting up to walk over to where he was found. Also, he's not out wandering around and then falling down in that location hours later so that he could end up on top of the snow. In addition, the blood stain pattern on his clothing shows that he was in an upright position while actively bleeding. If he couldn't sit or stand on his own, that would mean he was propped up somewhere. This points to the involvement of somebody else. The doctor testified that the head injury is not consistent with a fall on the grass or even snow. He was asked, what significance does the absence of injuries have? And he pointed out again, there was no bruising. And there was no bruising to the torso either. He said there was a distinct absence, and it really struck him that those injuries were not there. He also noted the absence of injuries to John's legs. The defense asked if the injuries were consistent with the fight, and his answer was they can be. He talked about the laceration over the eye, scrapes on the face, bruises on the hand. He said those bruises on the hand could be defensive injuries. And I wish that they'd asked about an attack rather than a physical altercation, because a physical altercation suggests that the victim is fighting back, and it doesn't look like the victim was fighting back. It looked like he was defending himself. So the word altercation might make a difference here versus attack. On cross-examination, Lally asked, well, did you do the autopsy yourself? No, he didn't. And Lally focused in here on something. He got the witness to agree there was no injury to John's left arm, left leg, or his torso. So that tells me that Lally's focusing on the right side of John, and I think he's going to try and use that in some way. Lally asked him if he agreed with the medical examiner on cause of death. The witness said yes, he does. He also agrees with the neuropathologist. And I want to point out here that Lally once again omitted something, and that is the manner of death. Everybody agrees on the cause of death, but that leaves out that the ME said the manner of death was undetermined. And I suspect that Lally wasn't going to ask this witness what he thought of the manner of death, whether it was a homicide, accident, undetermined, etc. Lally was asking about John's arms being in contact or not with the SUV. It doesn't matter. The answer is this wasn't caused by being struck by the SUV. But you know what it does show? He was in contact with a dog. And that means he was also in contact with Brian Albert, who was the one who stayed with the dog. Lally asked him, have you ever seen a case where an animal attacked only one part of the body? Oops. Well, the answer is yes. The witness went on to describe a couple of different instances, and he remembered a specific one where it was only one location, and that happened ante-mortem, meaning before death. Lally asks him about the animal marks on John's arm, and Lally asks him if he can say definitively what type of animal. And the answer is no. Again, if it's an animal, it's not an SUV. Lally asks, can you tell what breed? And the witness says no. Can you tell whether it was inflicted inside the house or outside the house? No. It doesn't matter in some respects. There are two things that matter here. One is that it's not a Lexus, and two, it means he was in contact with an animal prior to death. And what animal is there? And what animal is not out of Brian Albert's sight when there's company, which means he was in contact with Brian Albert. Lally asks, well, you can't tell when these injuries occurred. And the witness says, well, it would be minutes to hours before death. Lally asks him, are you aware that there was no dog DNA found on Mr. O'Keefe? Again, it's all besides the point. And by the way, Lally, of course, leaves out the fact that there was pig DNA found on the sleeve of the shirt where those teeth marks were. And of course, the witness doesn't know that, but it's not his job to know that. It's not going to change his assessment of the injuries and whether or not they were caused by an SUV. Then Lally went to a place that just was ridiculous. He asked the doctor if he was aware of the bite history of the dog that lived at Fairview, and the doctor was not aware. I think this is actually a good thing that he's not aware because it doesn't bias him in a certain direction. And Lally says, well, are you aware of photos of injuries of that later bite attack? And the witness says, no. Well, that's rich. With Dr. Russell, Lally brought up a paper on forensic odontology in humans, by the way, not dogs, and tried to make it sound like the field had been pretty much discredited. And Dr. Russell pointed out to him that that's not quite what that paper was about. And what was being cautioned about in the paper is matching specific bite marks to specific humans. Now, Lally is implying here that this doctor should have compared specific teeth marks to match a specific dog. I guess Lally thinks science is valid or invalid depending on what he wants people to believe rather than on what the science does or does not show. This should be a concern for the public that a prosecutor would do this. Lally asked, are you aware that there were microscopic pieces, 1/16 of an inch, of taillight on Mr. O'Keefe's clothing? Well, the witness is not aware of that. And by the way, 1/16 of an inch is not microscopic. You can see that with your eyes. Lally asked, are you aware there was DNA found and hair found? And the doctor was not aware. It doesn't matter. For the doctor's purposes, it doesn't matter. It's not his job to solve the whole case. He's looking at the injuries. This is just Lally repeating and reframing, by the way, things that he wants to drive home his version and his theories to the jury. He's basically making arguments here. This doctor looked at injuries. We already know that bits of taillight could have ended up on the clothing in other ways. And by the way, the bits of taillight were consistent with a taillight. They were never actually matched to Reed's taillight. Lally asks him, in blunt object injuries, are you aware that characteristics of that object can be transferred? And the doctor says, yes, of course. And Lally brings up this piece of plastic. You remember that clear piece of plastic with dimpling in it? And the witness doesn't recall specific pieces. And the fact that he didn't recall that piece of plastic is important. You see, this witness has so much experience that if he'd seen something in the photos that matched the injuries, it would have jumped out at him. The fact that it didn't does matter here. Oh, and speaking of jumping, in order for that little piece of plastic to make all of those injuries on John's arm, which according to all the doctors, it couldn't have. But even if you put that aside, that little piece of plastic would have had to hop up and down his arm a bunch of times and scrape along because the surface area of the arm is far bigger than the surface area of the object. Lally asked him, do you know what a compression abrasion is? This is as insulting as when he asked the ER doctor, do you know what cardiac arrest is? And by the way, we never did find out who ordered blood tests for Karen Reed. The witness says, yes, it's not a term we use all the time. And there has to be movement to get an abrasion. And with that answer, I think Lally realized he needed to move on. Lally said to him, well, most pedestrian vehicle accidents occur at the front of the vehicle. He asked him if he was aware that the vehicle had rear backup cameras. Well, it doesn't matter. If the injuries are not consistent with being struck by the SUV, it doesn't matter whether there are cameras, whether they're not, whether she was sleeping. None of it matters. He's just wanting to repeat certain concepts so he can string them together and weave them into something. And he repeats testimony, but he reframes it as he repeats it. Lally asked the doctor if where the person's center mass is, if that matters, and the answer is yes. Lally asked, would being hit by the right rear of a vehicle cause a pelvic injury? The doctor says it depends on the position of the victim, but you'd still see bruising.
You talked about a couple of different patterns to the injuries that you observed on Mr. O'Keefe's right arm. So my question for you, doctor, is it your testimony that those, what you're terming as animal bites or scratches, were they caused at one time or multiple times, or how many times are we talking about?
You mean on different occasions?
As far as there are multiple abrasions, as you've termed them, and you're attributing them to an animal attack, correct?
I think that's the most likely explanation for these, yes.
And so my question is, sir, is that from the dog or the animal or whatever it is scratching Mr. O'Keefe once, more than once, based on what you observed in?
Well, it's more than once. When I had the laser pointer here, I think I pointed to roughly, 1, 2, 3, 4 different areas. So it looks like, and you have, there's an additional, the ones on the lower forearm, on the forearm, I should say, are harder to figure out. But it looks like 4, maybe 5 separate.
4 or 5 separate sort of swipes, whether they be with mouth or paws or whatever.
Yeah, that's correct.
And so is it your testimony that it's not possible that Mr. O'Keefe received that from some part of the motor vehicle, or a glass shattering, or shattering from a taillight, or any sort of metal pieces underneath contained within that taillight housing as far as his interaction with the vehicle?
They don't look remotely like that to me.
So it's not possible, is that correct?
In my opinion, no.
Not remotely like that. Lally asked, what about if the surface of the ground was frozen? And the witness said, even if there was a coating of ice, it would not change my opinion.
Now, as far as the hard surface that you're talking about, would that include asphalt pavement?
Yes, it could. Mm-hmm.
And as far as those injuries, the speed, if Mr. O'Keefe was struck by a vehicle and was projected away from that vehicle and then struck his head on the ground, would that be sufficient force, in your opinion, to cause a skull fracture on the back of his head?
If all that happened, yes, and onto asphalt or something like asphalt, yes, if that's indeed what happened. But like for other reasons, I don't think that is what happened.
Did you notice that? If all that happened, but I don't think that is what happened. Lally is trying to discount or diminish the idea of a physical altercation, and he tries to use the bleeding in the eyes, and the doctor tries to clarify because Lally is not being accurate even in his questioning. The doctor explains it the same way as the Commonwealth's own witnesses. The medical testimony of the Commonwealth witnesses and the defense witnesses are the same here. This witness explained the fractures to the orbital plates, and then listen to what Lally asks immediately after the doctor explains this.
I mentioned the fractures earlier on that came from the back and went all the way towards the front of the skull, including what are called the orbital plates, which are the bones, the parts of the frontal bone that are right over the eye sockets. And the bone there is very delicate. It's the thinnest part of the skull. Anyway, the photographs and the autopsy report clearly show that the fracture involved that on each side, both orbital plates, in other words. And it's that fracture, it's not the brain itself, but it's that fracture which leads to the bleeding that causes the black eyes, if you want to call them that way.
And as far as what your review of the medical records, your review of the autopsy report, photographs, things like that, you observed nothing as far as fractures to Mr. O'Keefe's eye sockets, correct?
Well, the orbital plates, in a sense, are part of the eye sockets, but they're the roof.
The witness does say he didn't think the fractures came from the front. Lally asked about the minor lacerations on the face and if there was bruising on those. The doctor said it's hard to tell because it's mixed with the other hemorrhaging under the eyelids. And Lally incorrectly reframes this. Listen to what he said.
As far as the minor injuries that you were talking about, as far as the eyelid or the nose, as far as those minor lacerations you were talking about, there was no bruising around any of those lacerations, correct?
The eyelid laceration, don't forget, is in the same area where you have the other injury, and it's a little bit hard to figure out whether how much hemorrhage, how much of that black eye could even be from related to the laceration, because you've got two possible explanations for the black eyes. One is the skull fracture I've already mentioned, but that doesn't rule out his getting an impact as well from the front, but there's no way you can separate them.
But as far as around those minor lacerations that you're talking about, you didn't observe or see any record of any bruising or any broken bones in those areas whatsoever?
No, the main one but the altercation question was the laceration on the eyelid. That's not related to the head injury that we've been discussing. So it's a separate injury, and it is from some kind of blow to the front.
They are separate blows. Then there is a key bit of clarification that destroys yet another aspect of Lally's narrative. Do you remember Dr. Scorty Bellows' testimony when she distinguished between laceration and cut? A laceration is a tear in the skin caused by blunt force, while a cut is caused by something sharp. This doctor, again, supports the Emmy's testimony, and here it is applied.
Minor lacerations that you observe, would they be consistent with being struck by broken pieces of glass or broken pieces of broken sharp pieces of plastic?
If it was indeed a laceration, as it was described, then no, because lacerations by definition, although this is a term that's often misused, by the way, even by some doctors, but a laceration by definition is an open wound caused by blunt force, not sharp.
So Lally's theory that the facial injuries came from shards of tail light or glass has just been flushed down the toilet. So Lally changes it slightly. Listen to this.
So blunt force, as far as what I'm asking is it possible that the lacerations to his face were caused by a blunt object that then shattered and caused the lacerations to his face?
I find that hard to imagine. I find that very hard to even conceive of.
Now Lally has an intact taillight striking the face, causing a laceration so that it matches with what the expert is saying. Never mind that Lally has just tossed out his entire theory, including his own witness's reconstruction, and then he has the taillight shattering, which then causes lacerations, which the doctor just told him would not be lacerations. If caused by shattered taillight or glass, they would be cuts, and these injuries are not cuts. Look at this still. What do you suppose this guy is thinking and is too professional to say out loud? Then Lally asks him, "Did you see an animal on the scene?" Good Lord! On redirect, they pulled up a photo of John's knees so that the jury could see this injury that they keep referring to. The next witness was Dr. Daniel Wolfe. He works for ARCA, Forensic Engineering and Accident Reconstruction. The military has used them. One of their specialties is accident reconstruction and human factors. He has a PhD, ongoing education, he's accredited, and the list of qualifications was long, and it included the Toyota software, the same Toyota software that Trooper Paul was unfamiliar with, and so unfamiliar with that he didn't even recognize until a day later that it might be useful. So he didn't go get it till the next day, and that he said he was just learning about.
So I have a number of papers in the field of lighting and optics. I have a recent publication that deals with Toyota and Lexus vehicle control history records as well.
Is that called Toyota Vehicle Control History, sudden braking history recording characteristics?
Yes, sir.
All right. Was that specific to dealing with vehicles and their interaction with other vehicles and or pedestrians?
It involved looking at the various triggers that system is capable of recording. And specifically, it was looking at what triggers a sudden braking event. So we were able to determine that those triggers, the sudden braking event is triggered when a driver, or I should say the vehicle, reaches...
May we approach?
This witness was not hired by the defense. He never met any of the defense team before. He did not know the prosecution or the defense at the time he wrote his report. However, his work was provided to both the defense and the prosecution. This witness was equally available to both sides. This is important. It means Lally was aware of the contents of the report, and Lally did not reach out to this expert. This firm was tasked to do accident reconstruction, and this witness did that with his colleague, Dr. Rentschler. Dr. Rentschler was more focused on finding if there was a specific mechanism of injury to John O'Keefe, whereas this witness was more focused on the damage to the SUV. But the two experts had to work together. He said they looked at 10 categories of information. They listed all the things they looked at. And when Jackson asked him if he saw the leaf blower video, it seemed to me that the witness was trying to keep a straight face. And Jackson asked him, "What can you say about those photos?" And the witness said that it was difficult to follow the evidence through the photos because the photos were not taken in any kind of context. You'd get a close-up of something and not where it was in relation to anything else. And every CSI who has watched this knows that the photos that we all saw are not how you're supposed to do it. There were a few with the ruler, which was great. And I think we saw one photo of a piece of evidence in context, but the rest weren't. This firm was tasked with figuring out if the damage to the Lexus was consistent with hitting the victim, and if the victim's injuries consistent to being hit by a vehicle. They talked about the bumper, and the witness said it's common to see damage to a bumper in a collision, at least bumper displacement, also other damages to the vehicle in the area. The witness said there was no damage to the Lexus consistent with hitting a pedestrian. In respect to the glass on the bumper, Jackson asked if there were any pieces of glass inside the housing of the taillight. I thought that was a good question, because if the theory is that she backed up into O'Keefe and struck that glass, which would put glass on the bumper, right? Well, we should see glass inside that housing, but there wasn't any. The witness said there was no part of the taillight made of glass either. And the witness said the glass on the bumper could not have come from the taillight. We already know through forensics that the glass on the bumper did not match the broken drinking glass. He said they did testing. They did projection testing to the taillight. He said when they viewed the taillight, they knew it was potentially a small object that created that. Now, Jackson wasn't trying to elicit this information. This is the first time Jackson has asked him any questions, and the defense was not allowed to do any witness prep here. I think the mention of the taillight being damaged by a small object is an important tidbit. These experts wondered if maybe somebody threw the glass at the taillight. So they tested that. He also said that at the time they were doing the testing, they had not ever heard of the Karen Reed case, and the entity who hired them specifically instructed them to not do any outside research into the case because this entity wanted to ensure the analysis was based solely on the evidence. Yes, yay entity. They got back to the drinking glass. For the testing, they built an air cannon, and their target speeds were between 30 and 40 miles per hour. And the reason they chose that is because because a healthy adult male chucking a glass really hard would be able to throw it that fast. And they got varied results. He said it depended on the rotation of the glass. So they got results at 31 miles per hour and 37 miles per hour. And he said they were able to create damage consistent with the subject taillight. And Jackson said, during the test, the taillight was not moving, correct? And he said, correct. And the witness agreed that if the SUV struck a person holding the glass, it would not produce the same result. The witness agreed that he had no information that O'Keefe threw the glass. They were just looking at all the angles and possibilities. They also did drop testing, and this is in respect to the head injury. And they were specifically looking at what would happen if the victim interacted with the taillight. They used 7.5 feet and 15 miles per hour. He said 15 miles per hour in reverse is fast. He said at 15 miles per hour, you start to see significant injuries to the human body when it makes contact with the vehicle. And just a reminder here, the Commonwealth is not saying the SUV hit the head, but they're doing this testing because they don't know all this. They were supposed to just look at the evidence, and so they're looking at all the possibilities. So the tests show at 15 miles per hour, if the taillight hit the head of the victim, it would cause a lot more damage to the taillight than the damage seen on Reed's taillight. An increase to 24 miles an hour would even be more of a difference. Their conclusion was that the damage on the SUV is not consistent with it striking the victim's head. They moved on to the arm. Between the taillight and the dent in the back of the car, there's 20 inches. And the witness was trying to explain these measurements, and Jackson was trying to get out, okay, if the taillight hit the victim's arm, how does that affect the damage on the vehicle? And the witness is explaining, but Lally's objecting. Personally, I found this frustrating because nobody has sat down with this guy. So nobody knows what it is he has to say, but whatever it is, Lally doesn't want him to say it. The witness does get to say that between the dent and the light, there was no damage which would be expected if an arm had been positioned there. Jackson asked him if he would be able to calculate the force required on an arm only in order to project a person or throw a person. And the witness said if the person was struck only on the arm, there would be no projection of the body. The witness said that the absence of damage is inconsistent with striking the arm, which means it didn't happen. Jackson asked, what would you expect the damage to the taillight to be at 15 miles per hour or above if it struck the victim's outstretched arm? And the witness said he would expect deformation to the paneling in addition to more damage to the taillight. And here's the conclusion of this witness.
Last question, Doctor. In your expert opinion, based on all your testing, is the damage to the taillight that you saw consistent with striking a human head?
No.
In your expert opinion, is the damage to the taillight consistent with striking a human arm?
No.
Thank you. That's all I have.
On cross-examination, Lally said, so you can only work with the information you were provided, right? And of course the answer is yes. So Lally relists all of the information that they looked at, and Lally said, there was no mention in your report of the shoe and the hat. Were you not aware of that? And the witness was aware. Lally asks him, have you ever been at a live scene? Well, the answer is yes. Oh, well, how often? The answer is not often, because often they're called in much later. But you know what? Neither was the Commonwealth witness. And Lally wants the witness to say that it is common for a victim's shoe to fall off. And this is Lally wanting to focus on one thing that might fit as if it cancels out everything else. But this time, it backfired on him. Listen to the response.
You have some familiarity through working as a crash reconstructionist with pedestrian collisions, correct?
Correct.
is it common or uncommon for in the course of a pedestrian collision, for a shoe or glasses or a hat or something to fall off of that pedestrian in the collision sequence near where the area of impact occurs?
Well, I think that depends on the interaction between the two. If it's more of a side swipe type interaction, if we're just talking about an arm, for instance, contact the vehicle, no, I would not expect the shoe to come off. If it's something where the entire body is interacting with the vehicle, then yes, there's a greater likelihood that something like a shoe will come off, yes.
And after this, Lally asked again and got the same answer. And then he's asking if it's generally consistent. Hey, we're not here to prove beyond a reasonable doubt any other collision occurred in a certain way. And the witness still didn't answer yes, because that's not the answer. He said shoes can come off. And then Lally tried this bizarre kind of backwards list of questions that went nowhere. Like, well, the damage was isolated to the taillight, right? And I think he was trying to take this somewhere, but it wasn't quite coming together for him. Anyway, he ended up abandoning it. It didn't go anywhere. Then he asked about visibility, and he asked a bunch of nonsensical questions. And I mean nonsensical. And Lally seemed to be trying to speak on this guy's level, and he couldn't. And it was painfully clear and difficult to watch. And Lally went on about different possibilities for different injuries, depending on different factors. Man, this trial is about this alleged incident. The witness has already testified that in this incident, the damage to this SUV is not consistent with it striking the victim's head or arm. But Lally wants the jury to look at other things within the realm of possibility. Generally, his reasoning has gone so far off, it has officially entered outer space. Then Lally asked about how they controlled variables. And he asked specifically about temperature. How did you control that? Well, I think he didn't get the answer he expected. You gotta watch this exchange.
In scientific experiments, or in the world of scientific experiments, there are certain things called variables that you're trying to account for. Is that correct?
I would say that's fair, yes.
And essentially what you're trying to do is control as many of those variables as you can in order to best replicate whatever the conditions were at the time that what you're testing to see actually occurred. Is that correct?
Correct.
Now, what, if anything, did you do to control variables in relation to temperature?
So one of the things we did with all of the tail lamp assemblies that we tested is that we preconditioned them to approximately 28 degrees so that they'd reached a steady state temperature before we subjected them to the impact testing.
Lally asked about variables in weight.
Well, when you're talking about a projectile such as a glass, again, that's being projected at 37 miles per hour, again, there would be probably minimal effects in terms of the wind.
Even if there was a blizzard going on?
Again, what we're going after here is ultimately conducting a test such that the drinking glass arrived at the location of the taillight. So if you're trying to say that, okay, he threw it this way and the wind blew it towards the taillight, sure, that could be a possibility.
And sir, I'm not trying to say anything. I'm just asking, are you aware that there was a blizzard and that there were wind gusts up to 37 miles per hour during the time that this collision occurred, and that's not accounted for in your test?
Were you aware of that, sir?
I'm aware that there was inclement weather at the time, yes.
At the time? Well, Lally's lying. That blizzard wasn't until hours later. Lally wasn't getting anywhere with all this, so he went after the glass.
Now, with respect to what type of glass did you use?
So we used a rocks drinking glass, so that's a glass that has a thicker base and a shallower sidewall.
And so what I'm asking, sir, was it a cocktail glass? Was it a pint glass? What kind of drinking glass are we talking?
A rocks drinking glass.
There's no point in this. The witness said he examined the fracture pattern and targeted the test there. Lally went on about John's injury being to his right side, and he talked about his other injuries in detail. Lally knows that this witness is not allowed to get into all of these specifics about John's injuries. That's for the other guy. But Lally's going here because it gives him an opportunity to repeat things from his own narrative so that the jury hears it over and over and over. And he's going to use this right side injuries thing later at some point. And Lally said to him, well, what about visibility? Did you do a visibility analysis? And the witness did not do a visibility analysis. It was not in the scope of what they were supposed to do. It wasn't relevant. And Lally wants to make it appear that because the expert didn't do this other analysis, that he didn't consider everything. The witness said they were asked to determine whether the victim's injuries and the damage to the SUV were or were not consistent with an interaction between the victim and the vehicle. And, of course, this is their specialty. It's not their job to solve and argue all elements of the entire case. And you bet Lally would be objecting his head off if a witness started opining on areas outside of their scope, especially if it went against what he wanted the jury to hear. Then Lally comes out with, so you were restricted in your scope. Ooh, Lally knows that people noticed his digital forensics experts were restricted in what they were allowed to look at. There is a difference between narrowing the scope of a question and restricting a witness from examining evidence that would help answer that question. Lally is trying to both rehabilitate the perception that people have of him and cut down the work of this expert at the same time. If the listener sees this as a negative on the expert's work, it doesn't improve the perception of what Lally did, but it doesn't matter if he can dampen the point of the arrow that science has fired at Lally's theory. If the listener thinks it's okay, the scope is narrowed, then they might also, by association, think that what Lally did was okay. Either way, Lally wins, unless the listener recognizes the difference between scope of a question and restricted scope of relevant information. Relevant being a key word here. This is a good time to point out again that this witness was not hired by the defense. Lally asks if the witness was aware of statements made by the defendant. Oh, this is slimy. Aside from the fact they are alleged statements and are in dispute, that has nothing to do with the physics and is not relevant to the work of this witness. This is Lally trying to inject an incendiary thing into the mix to remind the jury of it and to present it as if it was established fact and somehow use it to make it appear that this witness should have considered it. This is nonsensical, dirty game playing, and the mental gymnastics aren't even sophisticated. Ridiculous. The next witness was Dr. Rentschler. They went through his qualifications. He's highly qualified. And they went through a similar process in questioning. He said the head injury to John O'Keefe could not have been caused by the SUV. He said the injuries to John O'Keefe's arm were inconsistent with being struck by that SUV for a number of reasons. He said the head injury is consistent with falling backward on concrete or a roadway, but not grass. He said if the arm was hit by the taillight, it would cause substantial damage to the arm, not just those abrasions. There would be significant trauma, and there's not. He also said that the abrasions on the arm have a similar amount of force to them, and the taillight would not produce that. Also, the measurements of the arm don't match the measurements of the taillight. If it was just the arm that was struck, he said even if you had a metal pole attached to the arm, it still would not cause the body to be thrown. If the victim was struck center mass, then the injuries would be completely different. If he was struck on the side, then he would have injuries on both sides of the body. One where the vehicle hit him, and on the other side where he would hit the ground. The cross-examination was essentially the same questions as what Lally asked the other witness. If I was a juror, I would be mad right now. I'd be mad that I had to sit through weeks of this when the information was right here. Lally started his bit with the dimpled piece of plastic. Yeah, seriously. But then he didn't follow through. He just sort of abandoned it. He went instead for the issue of DNA being on the taillight housing. But the way he did this, so he could phrase it a certain way, he used the expert's report and said, you would have expected to see blood and DNA on the taillight housing. And then he asked the witness if he was aware there was DNA on the housing. Lally is playing with words and concepts and associating them together so that when people remember, they associate those two things together. And he might be counting on people not fully understanding that there is a difference between blood and DNA. Well, the witness answered he knew there was a small amount of DNA. And he kind of shrugged like it wasn't a big deal. And the witness said, but there was no blood. And I'm glad he said that. A lot of people get confused about the difference. John's blood was not on the SUV or that taillight. And Lally's repeating his narrative again, saying O'Keefe's blood was found on the drinking glass that was found on the scene. So he's telling the witness this. Of course there was blood on that drinking glass. The glass was under him. And yes, I know there was another witness, police reconstructionist, who said, oh, the glass was beside him. But earlier testimony was that it was under him. Either way, the glass was with the victim where he was bleeding. So of course there's blood on that glass, but there is no connection between that drinking glass and the SUV. That has been proven. And I think it's disgusting that this man is trying to convict somebody based on misunderstanding, confusion. Lally brings up the tiny pieces of plastic that were consistent with taillight in O'Keefe's clothes. And again, this does not change the physics, no matter how much anyone wishes it. And in answering, the witness mentions, well, there were no pieces of plastic found on the body. And that's what he would have expected to see. Lally asked about frozen ground and the injuries. And this witness said you'd have to look at the freeze and thaw patterns for the weeks preceding that. Well, we know that the ground had not been frozen for weeks. The ground would not have been hard enough. Lally says, but you didn't do that analysis. You didn't look at those patterns. And the witness said, no, we didn't need to. He said even if the ground was hard enough, the strike from the vehicle would not have caused him to land there. Listen to this about the causes.
A bat could cause it. There's numerous different possibilities, and we don't really have enough evidence in this case to determine what one specific event actually caused that injury.
You didn't have enough evidence based on what you were provided. Isn't that fair to say?
I didn't have enough evidence based on what I was provided, and even looking at the additional evidence that I became aware of after the fact, there's still no evidence. I mean, you can't deny the science and the physics as to what would have happened if he was struck by the vehicle.
That was the end of that testimony. It has been clear from early on in the trial that Reed couldn't have hit him, in spite of everything. And although people were talking about the snow, it was snowing, and they're tired of hearing about the snow told the story. And there are a whole lot of people really not listening to that quiet but important story. There was no snow on the ground when Karen Reed was there. That snow didn't fall until hours later, and John O'Keefe was found on top of snow. In addition, it's clear that John O'Keefe interacted with a dog or animal. That's not Reed. She's not guilty. We also know that John was not out there even at 2:45 a.m. And we know Reed was at Meadows and didn't leave until the morning. She couldn't have hit him. She couldn't have done that. And today's testimony has made it crystal clear. Reed's SUV did not hit John O'Keefe at all. She cannot be guilty. His injuries do not match being hit by an SUV. The prosecution must prove beyond a reasonable doubt that Karen Reed did the things that she's charged with doing. And today there was evidence presented. Proof beyond a reasonable doubt that Karen Reed is not guilty. The defense only has to raise reasonable doubt, but what they've done is prove her innocence beyond a reasonable doubt. That's all I have for you today. Trust your gut. I'll see you in the comments.